Hey Andrew, can you tell me some more about the compulsory medical examination in a personal injury case?
Sure. Yeah, today's topic is going to be a little navigation guide for claimants who are undergoing compulsory medical examinations in their personal injury case. So a little bit of background about what it is. Um, it's kind of what it sounds like it is. It's a medical examination. It's a medical examination that injured claimants, plaintiffs, uh, have to undergo in personal injury actions, uh, always by a third-party doctor who years ago they used to call them independent medical examinations. We don't do that in Florida anymore. Some states still do because they're not independent. The doctor is selected by the defense attorney or the defendant in the case, and they know who they're working for. And so it's not at all independent. It's a defense examination. And in Florida, we recognize that we're allowed to call it a defense examination, but they're compulsory. And all states in the United States allow for compulsory medical examinations in civil personal injury cases. It's a standard practice under the rules of civil procedure in most states, and they all have provisions that are one way or another similar to what we have under the federal rules of civil procedure, and that's Federal Rule 35. Uh, Most personal injury cases are brought in state court, and so you're operating under the state rules of civil procedure. And here in Florida, we call it the compulsory medical examination. And what happens is the defendant's attorneys, they request it, and you can raise objections to it, but usually they're granted. And the claimant, under those circumstances, then needs to go to the examination and meet with the doctor who's been selected. It can be a physical examination or it can even be a mental examination, depending on the type of case. And it's usually in a specialty that's involved with the injury. And in Florida, you're allowed actually to have multiple examinations if there are different specialties that are needed for the compulsory examination, such as an orthopedic surgeon and a neurologist or a neurosurgeon. So different specialties can be involved in the compulsory examination. Uh, the practice, as I said, is it's codified, it's in the rules, and it allows the court to order a party to undergo a medical examination when their physical or mental conditions in controversy, meaning it's disputed. And the primary purpose is to allow the opposing party to obtain an independent medical evaluation of the plaintiff's injuries or condition that can then be used as evidence in the case. And typically, a party requesting the compulsory medical examination, as I said before, would file a motion with the court specifying the scope of the examination and the proposed examining physician. Uh, Now, there are things to know that uh, an injured person should keep in mind when they go to this examination. Firstly, okay, uh, you have to prepare for the examination. Now, when I mean prepare, what I'm talking about is this. Know your medical history so that you can explain your medical history to the physician. Review your injury history, past treatments and symptoms, and be familiar with the dates of treatment of the surgery and any prior injuries that you may have had. Be honest, uh, be brief though. Don't elaborate. Don't go off on tangents. Just answer the questions. Answer the questions truthfully, but don't volunteer extra information. Just stick to the facts and don't speculate about anything that you're not sure of. Now, if you're allowed, you can bring someone with you. Very often in Florida, lawyers or someone from the lawyer's office will attend the examination. We're allowed to do that. We're also allowed to have a videographer there and record it. Sometimes lawyers will just send the videographer along with the client and record the session. And the lawyer will then review it afterwards to see what was done. Now, why is that important? It's important because if the defense examiner says they did something in their report, but the video shows that it didn't happen, or that the patient never complained about something or said something that the patient disputes, you've got a video and an audio record there to clarify and to point out exactly what it is that happened. Okay, so you can bring a witness if allowed, your attorney or videographer, and avoid exaggeration. Be accurate about your pain levels and the limitations that you're having, because overstating your injury can affect your credibility. Meaning, if you exaggerate, a jury will pick up on it. Okay, and generally, juries will punish injured claimants for exaggerating their injuries. So you want to be truthful, you want to be accurate, and you just want to tell them what you're really experiencing. Uh, Treat the examining physician with respect. Hopefully, they'll treat you with respect as well. Don't let them push your buttons. Okay. And even if you feel that they're being biased against you, okay, maintain your composure. It's especially necessary if you're being videoed at that time. Um, Now, what's going to happen during the exam? During the exam, you're going to be asked about the accident and the medical history. In Florida, you don't need to talk about the facts of the accident. Okay, you don't need to describe who did what. You don't need to say, oh, the other fellow ran the stop sign or ran the red light. You do not need to describe your actions in the course of the injury. All you need to do is talk about your medical history and the injury that you sustained. Okay, the doctor is then going to perform a physical examination, okay, and ask you to move various parts of your body. If you're complaining about leg pain, they're going to move your legs. If you're complaining about hip pain, they're going to move your legs and rotate it so that the hips will be involved. Same thing for neck injuries, and they're going to physically examine you as well. You may be sent for x-rays. Generally, the examining physician, the compulsory examining physician, will have your records in front of them. They'll have been sent to him or her by the defense attorney. They'll have reviewed them. They will also have reviewed x-rays that have been taken, or MRIs, or CAT scans that have been taken previously. And depending on where you're having the test done, or where you're having the examination done, it may result in you having another imaging session as well. Usually it may just be x-rays. These usually occur at a doctor's office. Doctors don't have MRIs and CAT scans in their offices. And so you'll probably just have an x-ray done if the doctor feels that's necessary. Now, as I say, that physician will have reviewed all of these documents, and so they're going to know about your past medical history. So when you tell the doctor about your past medical history, be sure that you're up to speed and you understand what happened and the dates. Now, don't you're going to be observed in the way that you move, the way you sit, the way you walk. And so don't exaggerate again. Just walk the way you would normally walk. And if you're walking and protecting certain parts of your body because of your injuries, do that, but don't exaggerate it. And don't hide your injuries. Be honest about them. Don't say, oh, no, I'm really doing okay. If you're not doing okay, be sure to tell the doctor that you're not doing okay and what your specific problem is. But again, do not exaggerate. Now, keep in mind, okay, you're being evaluated from the moment you walk into that doctor's office. So you have to remain consistent in how you present your symptoms. Okay, now what happens afterwards? Once the exam is complete, okay, you should go home and take notes or record your notes as to what happened. Write down or dictate into your smartphone what the doctor asked, what tests were performed, and anything unusual about the exam. Uh, Notify your attorney, share the details of the exam with your attorney so that they can prepare for any disputes and the attorney can understand what happened. A report will be generated, and that report can be requested by your attorney. If your attorney requests the report, then your attorney is going to have to turn over any reports that he or she may have that have been done by their own doctor that they hired to examine you. In other words, once you request the compulsory medical examination report, then any reports that your lawyer may have to be turned over as well. Once your lawyer gets a copy of the report, your lawyer probably will want to review the report with you for consistency and accuracy, and to develop any areas that you might want to have your lawyer question the examining physician about. Now, here's a few final thoughts about it. Uh, the compulsory medical examination, they're a standard part of just about every personal injury case. Sometimes it doesn't happen when the client or the claimant or the injured party is so severely injured that the defense lawyer doesn't want to create another report that's going to document how severely injured the client is. So it may not happen in those cases. Generally, you find these exams occur when you have complaints that are that may be serious, but they're not debilitating, and they're not going to be a source of ammunition for your own lawyer when the defense examiner produces a report talking about how genuinely injured you are. Um, these exams, I mean, they can be nerve-wracking, okay, and you'll be nervous, but it's something that you just need to deal with. Be prepared, and understand that it's an important part of your lawsuit. And for your lawyer to successfully handle your case, you're going to need to navigate the compulsory physical examination to the best of your ability. I hope this has been helpful. I hope it helps you if you have to have a physical examination, and have a great day.